that question? Answer, because there is a principle or doctrine of transmissibility of rights. And the doctrine of transmissibility of rights is found as early as your obligations and contracts. It is found in Article 1178. And 1178 of your codal provisions tell you that all rights acquired in virtue of an obligation are transmissible. Let me say that doctrine again. All rights acquired in virtue of an obligation are transmissible. And 1178 gives us two limitations. The limitations imposed by law and the limitations imposed by stipulations. We are trying simply to rephrase 1178. There are rights of a person that are not transmissible. For instance, I'll give you a right that is not transmissible. Let's go to the law on partnerships for a while. I am a partner in a partnership. My friends are partners in a partnership. Some are capitalist partners and some are industrial partners. Let's say one capitalist partner dies. What happens to his membership in the partnership? Can his membership in the partnership be transferred to his eldest son? The answer is no. No. That membership in the partnership is not transmissible. In fact, it results in the dissolution of the partnership. Let's try to check Article 1830 of our code. Could you check it for a while? Let's go to 1830 of the Civil Code and let's probably look at number 5 of 1830. And you will find there that death of a partner is one of the grounds for a dissolution of the partnership. Now, did I say it right? Now let us check, for instance, let us check the rules on agency. Let's try to go to Article 1919 on agency and let's try to check number 3 of 1919. And you will find there that the relationship of agency is terminated or dissolved upon the death of the agent or the principal. Did I say it right? Is it there? Have you checked it? Yes, okay. So those rights are not transmissible. But let me give you an example from your past lesson in obligations with D. Navarro about rights that are transmissible. Let us say, Mr. C is the creditor. Mr. D is the debtor. Can Mr. C transfer his rights as a creditor to a third person? Yes, let us say the creditor transfers it, it is with his consent. The third person agrees that he will be the new creditor. Then the debtor also agrees that he has a new creditor. You remember 1301 of your Civil Code? That's actually conventional subrogation in 1301 of your Civil Code. The rights of a creditor here have been transferred by the consent of the parties. This is an example of a right that is transmissible. Did you check 1301? It mentions consent of the parties. So this is an instance where a right is transmissible because the parties have agreed upon it. Now, there are situations where people who are not parties to a contract, people who are not assignees, people who are not heirs, may have rights or obligations under a contract by way of exception. Let me clarify the general rule. The general rule is, if you are not a party, if you are not an assignee, if you are not an heir, wala kang pakialam sa contract, you are considered a stranger. Let's use a political law term. As far as the contract is concerned, you are a persona non grata. You cannot ask for the annulment of the contract as a rule. You cannot ask for its enforcement. You cannot claim a right under the contract. You cannot claim an obligation under the contract because of one simple reason. You are a stranger because you are not a party. You are not an assignee. You are not an heir. But are there situations when a person may have rights, may have obligations under the contract, even if he is not one of those three mentioned in 1311? The answer is yes. And the exceptions, if you want to look at the rules or the law in a holistic manner, you go to 1311 to 1314, and these are the exceptions to the general rule. And when we talk about 1311, we talk about the second paragraph. Okay, someone gave me a civil code here, and let's go to 1311 for a while. No, I won't read this. I'll just talk about this. But the second paragraph of 1311 talks about the first exception. It does not mention this French term, but 1311, second paragraph, presents the first exception when there is a contract pour autrui. That's the second paragraph. One exception is when there is a contract pour autrui. No, you close up. Make a close up of what I am writing. Now that's the first exception. Now what is a contract pour autrui? A contract pour autrui is a contract. Let's do it very slowly. It is a contract which contains a stipulation in favor of a third person. Let's emphasize that. It contains a stipulation in favor of a third person. That stipulation was clearly and deliberately written by the parties in favor of that third person. The person has a benefit under that particular contract, which was clearly and deliberately given to him by mutual agreement of the parties. The favor or benefit is not incidental. It was clearly and deliberately given to him. Now the next question is, if that stipulation was clearly and deliberately given to him, is it enough to give effect to the stipulation or contract pour autrui? The answer is no. It is not self-executory. It is not self-executing. The third person must first accept by notifying the obligor before the benefit or favor is revoked. So it is not self-executing. He must notify and communicate to the obligor his acceptance of the benefit. Here is a third person. He is not a party to the contract. He is not an assignee. He is not an heir. But there is a benefit conferred upon him directly and clearly and deliberately. It's not an incidental benefit. Now let us have a short illustration of this word. Let us now presume that Mr. CC is the creditor, and Mr. DD is the debtor. Let's talk about the amount of 1 million pesos. This is a contract of loan, and the debt is due on August 1, 2013. There was a stipulation in the contract which says that when the debt becomes due and CC demands payment from DD, DD is going to deliver the 1 million to his daughter NN. NN learns of the stipulation in her favor, and NN notifies D that he accepts the benefit or the favor. This is a stipulation for octroi. Now, why did CC give 1 million to NN? Maybe as a donation. In other words, NN is an intended donee beneficiary, clearly and deliberately conferred in the contract. See? NN is not an incidental beneficiary. NN is an intended beneficiary. And it appears that this is a donation. We call him or we call her a donee beneficiary. This is a contract for octroi. Let's use the same example. But this time, NN is not the daughter of CC, but NN is the creditor of CC also for 1 million. NN is the creditor of CC for 1 million. But DD is the debtor of CC. In this particular contract of loan, it was agreed that when CC demands from DD, DD is going to give the money to NN, the creditor of C. She accepts, there is a contract for octroi that is accepted. NN is an intended creditor beneficiary. But there is one point I wish to clarify. The benefit given to NN in this contract for octroi is not incidental. It is clearly and deliberately conferred upon her. Now let's try to erase this one and let us give you another example. Okay, let's talk about two people. Here is a taxi cab company. And here is Honda Quezon City, a dealer in cars. The taxi cab company had an agreement with Honda Quezon City to supply taxi cab company with 100 units of Honda Civic cars to be used in its fleet of taxi cabs. The truth is, Honda will not agree. Okay? That's the truth. That's why you do not see taxi cabs with the brand Honda. When you buy a Honda car, it's part of your contract. Do not make it a taxi. Okay. Now, Toyota, no problem. Okay. Now, look. Okay, look at this. So, what kind of cars does the taxi cab company need? Honda cars. So, there was a contract. But for some reasons we do not know, the contract fizzled out. Hindi natuloy. Honda Motors Corporation, who learned about the contract, is now coming into the picture and wants to file an action for a specific performance to compel the two parties to go on with their contract because Honda Motors said it had a benefit under the contract. Honda Motors said this is a contract that favors Honda Motors And so it has a right under the contract. Honda Motor said, this is a contract for autrui. And assuming it has accepted it, Honda Motor said, I have a right under the contract between Taxi Cab Company and Honda Quezon City, the dealer. The question is Honda Motors Corporation a beneficiary under a contract for autrui? The answer is no. True, it will be benefited by the contract, but the benefit is only incidental. It was not clearly and deliberately conferred upon Honda Motors. The benefit here is incidental. There is no contract for autrui. Let's have another illustration before I leave this topic. Here is a parcel of land, but it is 20 hectares. The owner of this land is Mr. A. And here is ABC Realty Corporation, also at the same time a Realty and Development Corporation. You know, this land have adjacent lands here owned by other private persons. ABC Realty Development Corporation had an agreement with Mr. A, the owner of the land, that ABC is going to develop this land, 20 hectares, into a commercial complex. Okay? What would happen to the value of the land here around the 20 hectares when it is developed into a commercial complex? It would appreciate in value. So they would be benefited. For one reason or another, the contract between ABC and A did not materialize. The owners now of this land banded together to compel them to go on with the contract because they said they are beneficiaries in a contract for autrui. The question is, are they beneficiaries in a contract for autrui? They are not. True, they will be benefited by the commercial complex, but that benefit was incidental to the contract. It was not clearly and deliberately conferred upon them. Maybe we understand each other. Okay, you try to go to another exception in 1312. And 1312 talks about contracts creating real rights. Could you help me with that? Are they contracts creating real rights? When the contract creates real rights, people who are not even parties to a contract will be affected by that contract. Let's have an example of a contract creating real rights. A mortgage contract, a real estate mortgage, creates a real right. Leases that are registered, leases of real property that are registered, create real rights. So let us have this example. Okay, let's talk about a parcel of land. And here is Mr. M.E., the mortgagee, and here is Mr. M.O., the mortgagor. The mortgagor borrows money from M.E., and because M.E., even if he is filthy rich, does not lend money without a collateral. So he asked Mr. M.O. to execute a real estate mortgage in his favor. Now, so this land owned by the mortgagor is now mortgaged in favor of the mortgagee. Mr. Mortgagor, during the existence of the mortgage, sold his land to Mr. BR, the buyer of the land. By the way, does Mr. MO, the mortgagor and owner of the land, have the right to sell his land even if it is mortgaged presently to Mr. Mortgagee. Yes or no? Yes. In fact, any stipulation prohibiting the alienation is void. Do not forget that. We mentioned that last meeting. Any stipulation that will prohibit the mortgagor from alienating the property mortgage is void. And our legal basis was 2130, if you remember. It will also be void if the contract says you can sell your land, but you have to get my consent. Oh, that's also void, because that will indirectly prohibit the alienation if the mortgagee does not consent. That is an indirect prohibition. That is Litonowa versus L&R Corporation. We mentioned last meeting in 320 SCRA. Okay? Now, who is the new owner of the land? The new owner of the land is Mr. BR. Now, Mr. MO did not pay his utang to Mr. ME. Can Mr. ME foreclose the real estate mortgage on the land which is now owned by Mr. BR? When the action for foreclosure was filed, Mr. BR objected. Mr. BR said, I was not a party to the mortgage. Under the doctrine of relativity, I have no obligation under that mortgage because I was not a party to the mortgage. 1312 says, no. You are obliged, your land could be foreclosed. It creates a real right. The mortgage follows the property. Whoever the possessor is, whoever who the owner is, whoever the possessor is, the mortgage will follow the land, even if BR is not a party to the mortgage. I want you to look at Article 2126 in relation to 1312. Okay, let's look at 2126 if my memory did not fail me. Please look at it. What does it say? The mortgage directly and immediately subjects the property upon which it is imposed. Take note of the words, whoever the possessor may be. Whoever the possessor may be. The mortgage on the land could be foreclosed even if it's now in the hands of a new owner, because it is a contract creating a real right. The same is true in a contract of lease. An apartment leased to Mr. X was sold to a new owner. Let us suppose the lease was registered. Is the new owner bound by the lease? Yes. He has to respect the lease, because a registered lease creates a real right. And even if it is not registered, if there is knowledge on the part of the new owner that there was a leasehold for a certain period, he is bound by the contract of lease, because knowledge is equivalent to registration. Knowledge is equivalent to registration. Now, the next exception is 1313. And 1313 talks about contracts in fraud of another person. Now, is it possible really for a person to be bound by a contract where the creditors are protected in cases of contracts intended to defraud them? The answer is yes. Actually, 1313 of your civil code is actually the general rule, while the specific rule is 1381 number 3. 1381 number 3. 1313 is very general, but 1381 number 3 is the specific rule on this. Let me just try to give you a general idea on this, because when we go to rescissible contracts, we're going to talk about this in detail. Okay. Here is Mr. Creditor. Here is Mr. Debtor. Mr. Debtor is a professional debtor. Mr. Creditor is a professional creditor. He lends and lends and lends, and he is a person who is easily convinced by his debtors. See, he is very gullible. So he's a professional creditor. This professional debtor knows beforehand he is not going to pay the debt. See? Now, you know what he did? He sold every property that he has. Because he knows that when he runs away from the creditor, he could run away. But his houses and his land cannot run with him. So what he did was, with the connivance of his brother, he sold his properties to his brother, who really paid the price also. Remember that in an action to collect a sum of money, the first option of the creditor is to file an action to collect the money. If he cannot collect the money because there is no money, he will run after the properties of the debtor. But there are no more properties to be recovered because they have been sold to B. So, here is a contract between D and B that was actually entered into to prevent C from collecting. This is a contract of sale in fraud of Mr. C. Now, Mr. C is not a party to the sale. He is a stranger. But under 1313, he could file an action to have the sale cancelled. Even if he is a third person, he could file an action for rescission because of the injury and the economic damage that resulted in the contract of sale between D and B. An exception to the doctrine that only parties and assignees and heirs are bound by the contract or have rights under the contract. Mr. C has a right to file an action for rescission. Simple. Number 1314 does not need a lengthy explanation. It talks about the liability of persons who interfere in the contracts. 1314 is actually the doctrine of interference of contracts, or interference in contracts. Because any third person who induces another to violate his contract shall be liable for damages to the other contracting party. He is not a party to the contract. Kung tutusin at susundin natin ang general rule, anong liability niya under the contract? Wala. But because of 1314, he induced another to violate the contract, he is liable for damages under the principle of interference in contracts or interference with contracts. That goes our doctrine of relativity. May I remind you to go to 1318 for a while, because we are now in the very nucleus of contracts. Now, what do you see in 1318? 1318 tells you about the essential elements of the contract. The consent of the contracting parties, the object, described as an object certain, which is the subject matter of the contract, and the cause of the obligation. Invariably, the word cause has also been mentioned as a consideration, the cause. Now go to 3019. 3019 tells you also about consent. And 3019 tells you how consent is manifested. By the way, is my voice too loud? Oh. 3019 tells you how consent is manifested. But one question I'd like to ask you is, why should consent be manifested? You know, a contract is a meeting of the minds. We must know what is in the mind of a person. And that must be externalized. We cannot talk in pantomimes. We cannot simply look at each other and let everything be implied. For instance, if I love a young lady, it's not enough for me to look at the lady. It's not enough for me simply to stand and then be starstruck. No. I have to go to the lady and say, "Holy smoke, young lady, I love you with all my heart." If she says no, I turn my back. If she says yes, I'll embrace her so tightly and throw her up in the air. But I wouldn't catch her. She falls down on her own. Okay? Now look, consent must be externalized. Because people should communicate with each other. And according to the law, let me ask you the question, how is consent manifested? Consent is manifested according to the law by the meeting of the offer and the acceptance. We must know it because we are not judged by what is internal but by what is external. We are not judged by what we think, but what we say and do and act. But the law in 3019 also tells us the main characteristic of a consent. According to the law, the offer must be certain. And the acceptance must be absolute. Now, what do we mean when we say, what does the law mean? What does jurisprudence mean when we say that the offer is certain? It means the offer must be clear. The offer must be complete. The offer must be definite. The offer must be with the intent to create a legal relation. Let me say that with feeling. It must be with the intent to create a legal relation. Let us be poetic for a little while. The offer must have the capacity to create a power of acceptance. Meaning, it must have the intent to create a legal relation. The offer must be certain. It must be clear. It must be complete. It must be definite. It must create a power of acceptance. It must be with an intent to create a legal relation. Suppose I tell you, I'm talking to my friend Bernardo and I said, "Bernardo, I want to sell my property." Bernardo says, "I accept." Is there a contract? There is none. What I said cannot be legally accepted. I want to sell my property. Which property? Where is it located? How much? I want to sell my property. Oh, that is not even an offer. It is so vague, so nebulous, it cannot be accepted. Suppose I say, I want to sell that house which I own. And he says, I accept. Is there a contract? No. First, it is not even an offer. It is simply a statement of an intention. I want to sell my house. It is even incomplete. For how much? But suppose I say, I am offering to sell that house to you. And he says, I accept. Is there a contract? None. Even if it is in the form of an offer, it is incomplete. How much? What's the price? In other words, if there is still a room for negotiation or the other party will still say, papano, kailan? Cash ba o installment? There is still no certain offer. Suppose I tell you, I am selling to you my house located at number 29 Pearl Street, Quezon City for 25 million pesos. And he says, I accept. Is there already a contract? Not yet. The offer is incomplete. Is it cash? Is it installment? The basic terms are not yet there. There is still no acceptance. It cannot be accepted. Remember, where the offer is not clear, not complete, not definite, and the answers I accept, since there are still matters that have not been touched on the offer, you are still in the preparation stage. You are still in the negotiation stage. You are still in the conception stage. Remember the three stages in the contract: the preparation stage, conception or generation, negotiation, and the second is perfection, and the third is consummation. You know those well. But can I point out to you some examples that were actually suggested in the bar exams before but never found their way? Let's say Mr. Buyer writes to Mr. Seller, please give me the lowest price you can give for a 2010 Toyota Camry with 3.0 engine displacement. That was one of the suggested questions. And then Toyota Motors answered 2.6 million pesos or 1.8 million pesos. Is there a contract? Look at the letter. Please give me the lowest price you can give to me for a 2010 Toyota Camry car. Toyota answered back 1.8 million pesos. Is there a contract? Is there an offer? Is there an acceptance? No, there was no offer to buy. It was simply an inquiry. There was no offer to buy. And the answer was not an acceptance. It was only an answer for a question or to a question. An answer to an inquiry. Now, could you open your codes for a while and go to 1321? 1321 tells you the prerogatives of the offer. 1321 tells us that the offerer is the master of the offer. The master of the offer. Because the person making the offer has the prerogative to fix the time, the place, and manner of acceptance. Time, place, and manner of acceptance. All of which must be accepted. If one is not accepted, the acceptance is not an absolute acceptance. I am offering to sell my house to you for 25 million pesos cash. He says, I am willing to buy it in 4 equal monthly installments. There is no contract. The offer said cash. The answer said 4 equal monthly installments. There is no meeting of the minds as to the terms of payment. Because the offerer said cash, the answer was installments, no contract. The offerer said, I am offering to sell to you my house for 25 million pesos cash. Please answer by letter. The answer was by phone. The answer was by text. No contract. Because remember, the offerer can fix the time, the place, and manner of acceptance. I am offering to sell to you my house for 25 million pesos cash. Please answer and accept by May 30, 2013. There was an acceptance of everything in the offer, but the acceptance came on June 5, 2013. There is no contract. Remember, the offerer can fix the time, the place, and manner of acceptance. He is the master of the offer. How do we describe an absolute acceptance? An absolute acceptance is an acceptance that does not change the terms of the offer. It does not vary the terms of the offer. In shortcut lingo, we call the absolute acceptance a mirror image of the offer. Kung ano ang offer, yun ang acceptance, then it is an absolute acceptance. If there is a change in the terms of the offer, the acceptance is a counter offer. A counter offer, according to the Supreme Court, changes the tenor of the offer. A counter offer rejects the original offer. There is no contract. Our laws have very strict rules on acceptance. I remember one case in 641 SCRA. It was a case of the Development Bank of the Philippines versus Riano. It was a case decided on February 7, 2011, 641 SCRA. The Development Bank of the Philippines was a stockholder and was a majority stockholder in a certain company called Paragon Paper Industries. And the Development Bank Company wanted to consolidate its ownership and have a higher percentage of control of the outstanding capital stock. So it offered to buy the shares of the other stockholders. So it wanted to own around 95%. Already it had a majority, but it wanted 95%. So one of its officers offered to sell his shares with a substantial number at 65 pesos per share. And he offered it also to DBP. DBP answered, we are going to buy your shares and we agree. under certain terms and conditions. The issue was whether or not there was a perfected contract. The Supreme Court said, none. There was none because your answer was, we accept your offer under certain terms and conditions. So there was a counter offer on the part of the Development Bank of the Philippines. So the Development Bank of the Philippines could not say it is now the new owner of the shares because its acceptance was not an absolute acceptance. That's why qualified acceptance is one that involves a new proposal because it is a counteroffer. So remember, for consent to be clearly manifested, the offer must be certain and the acceptance must be absolute. Now there are times when the offerer requires that the acceptance be by letter or telegram. When will the acceptance be considered as effective? When the telegram or letter of acceptance comes to the knowledge of the offerer. You look at the last part of 3019. I don't remember any bar exams on that, but look at that. And the contract there is presumed to have been entered into in the place where the offer was made. If the offer is made through an agent, communication to the agent will be considered as the acceptance. One very important concept is in 1324. You look at 1324, and here the offerer has allowed the offeree a period to accept. The offer may be withdrawn at any time before acceptance by communicating such withdrawal, except, however, if the option is founded upon a consideration as something made or promised. Is that what 1324 says? Okay. This could be a bar exams. Okay, here it is. Here is the seller. Here is a parcel of land. Here is the buyer. Mr. S stops the buyer. Mr. Buyer, I'm going to sell to you my land for 10 million pesos. The offer is to sell. Mr. Buyer says, holy smoke, baby, I like your land, but I can't decide right now. And so Mr. B says, can you give me some time within which to decide? Mr. S says, no problem. I'll give you 30 days to decide. The question is, before Mr. B has used up the 30-day period, can Mr. S withdraw the offer and offer the land instead to C? The answer is yes. Why? There is yet no acceptance. But is he not bound by the 30-day period which he promised to give Mr. B? There was a meeting of the minds as to the 30 days. There was consent as to the 30 days. By the way, while there was consent as to the 30 days, there was agreement as to the 30 days, there was no consideration given to the use of the 30-day period. We are talking about two potential contracts here. The contract of sale involving the land and the option contract involving the period. And every contract must have consent, object, and cause. With respect to the 30-day period, there was consent. What was the object the 30-day period. But there was no payment for the use of the 30-day period. There is no cause. The third element is absent. Therefore, he is not bound by the so-called option contract on the 30-day period because the option is inexistent. One element of a contract is absent. Remember, this use of the 30-day period is a contract separate and distinct from the sale of the land. This must have a consideration also as something paid or promised. Okay, look at this. S offered this land for 10 million to be, gave him 30 days. There was no consideration for the option. If he settled, he can withdraw the offer. Get my point? Can he withdraw it and offer it to C without even telling B about his withdrawal? The answer is no. He can withdraw, but the law is specific. The withdrawal must be communicated. While he has a right to withdraw, he has to communicate his withdrawal. Otherwise, it would be an abuse of right. He will be in bad faith. To avoid the bad faith, he has to communicate the withdrawal because of Article 19 of the provisions on human relations. That's why the law inserted that by communicating such withdrawal. He can withdraw, but it must be communicated. When you study the law on sales, you will have a similar provision to that under 1479 number 2. Could you visit that for a while? An accepted unilateral promise to buy and sell a determinate thing for a price certain is binding upon the promisor if it is founded in consideration. That is an equivalent specific provision in the contract of sale. Let me say the provision again, 1479 number 2. Did you see that? Did you see that? An accepted unilateral promise, etc. But there must be a consideration. If it is supported by a consideration, does it say distinct from the price? Yes, distinct from the price. Distinct from the price. Okay. S offers the same land. Let's have a replay of this. B was given 30 days. But then B said, okay, here is 1,000 pesos for the option. The 1,000 pesos is now a consideration for the use of the 30-day period. Mr. S cannot withdraw the offer within the 30-day period. He is bound by the 30-day period. Because of the consideration, we have created an option contract that is binding upon Mr. S. Now, is the 1,000 pesos a part of the purchase price na pwede mong ibawas? The answer is no. The option money is not a payment for the land. It's payment for the use of the 30-day period. It's distinct from the price. Like the one mentioned in 1479 number 2. Distinct from a price. By the way, the kind of money that is part of the purchase price is the so-called earnest money. But that earnest money is found in 1482. Could you check 1482? When the problem in the bar mentions option money, that's a different story. But when the bar exam mentions earnest money, it is part of the purchase price. And when there is earnest money, it indicates that there is really a perfected contract in 1482. Okay, did we get that class? Okay, let's go to 1325. Oh, business advertisements of things for sale. Are they definite offers? No, they are not. What are they called? They are only invitations to make an offer. Unless, look at the caudal, unless it appears otherwise. Okay, you read advertisements like this. House for sale, subdivision 1, Antipolo Rizal, 25 million pesos. Then you read the advertisement. You go there and you say, I am buying that. The owner says, no, I won't sell it to you. Then you said, pambihira ka naman, may advertisement ka. I am now accepting. There is a contract. Do you know that there is a meeting of the offer of the acceptance under 3019? I see in your karatula here, you are a lawyer. Is there a perfected contract? No. Because that advertisement is not an offer. It is only an invitation to make an offer. The one offering is the one who answers to the advertisement, which may be rejected or not by the person who made the advertisement. Oh, you get it? That's very simple. I don't think they will even ask that in the problem. But if you are taking the CPA exams, that could be asked. You go to 1326. Advertisements for bidders. Invitations to make proposals only. They are not definite offers. Can the person asking or advertising for bids reject the lowest bid or the highest bid? Yes. Because they're only invitations to make proposals. If you ask for bidders, you have no obligation to accept the bid. That is 1326. Now let's go to 1327. You select where you belong. I belong to the first. These are the persons incapacitated to give consent to a contract. By the way, these persons are not prohibited to enter into a contract. They are only incapacitated. When you are prohibited to enter into a contract, the contract you entered into is void. Because you are violating a prohibitory law under Article 5 of your Civil Code. Acts against prohibitory and mandatory laws are void. But the contracts entered into by those in Article 1327 are not void. They are merely incapacitated to enter into a contract. Okay, unemancipated minors. Insane or demented persons. Deaf mutes who do not know how to write. It did not say do not know how to read, do not know how to write. You look at 1328. I do not know why they added this. Contracts agreed to in a state of drunkenness. And what makes me laugh is the next. Those entered into during a hypnotic spell. Wow, how strong is hypnosis really? Incapacitated to enter into a contract. This was a time when there were so many movies about hypnotism. But look, you are not always insane all the time if you notice that. Have you observed yourself? You have the so-called window of opportunity. You are not always insane for 24 hours. You have a 2-hour window. You call that lucid interval. And contracts entered into a lucid interval are also valid contracts. The people prohibited from entering, let's say, into a contract of sale are those mentioned in 1490 of your law on sales. Do you remember that? Husband and wife. Remember that? 1490. Look at that. That could be in the bar. And 1491. About the guardian or the ward. By the way, if you look at 1491, you see the words cannot acquire by purchase, meaning you cannot buy. But the law does not say you cannot sell. You cannot simply acquire by purchase. That's why your lecturer in sales will tell you that 1491 is only a relative incapacity. It's not really an absolute incapacity. In fact, Article 1490 is more absolute than 1491. It's about husband and wife. They cannot sell to each other. In 1490, it is about selling and buying. Because when you sell to each other, one is the seller, the other is the buyer. In 1491, cannot acquire by purchase. It only refers to buying, not selling. There is another provision in your family code. Look at Article 87. Donations between the spouses, they are prohibited. In Article 87, donations between the spouses are prohibited, except moderate gifts. When do you attain your age of majority? Age of 18. Okay. Now, are all contracts entered into by minors? A contract said to be entered into by an incapacitated person? The answer is no. If the minor buys necessaries in life, don't tell me there is a defect in the contract. I go to the store and buy pandesal. I go to the school and pay my tuition fees and the minor is the one holding the money. That's not defective contract. He pays for his dormitory. He is only 16 years old, a first-year college student. Don't tell me it is a defective contract. So when a minor enters into contracts involving necessaries in life, then the contract is a valid contract. Okay, now, there is an old case, the case of Mercado versus Espiritu in 35 Philippine reports, where the minor sold his land to someone else. He was a minor. At that time, the age of majority was 21. I attained my age of majority at 21. My majority age was delayed by 3 years. You attained your age of majority at 18. Is it not? It was delayed. So when I was 20 years old, I was still a minor. It's nice to think about it. Now this minor sold his land, pretending and misrepresenting himself to be of majority age. Oh, let me try to give you a shortcut right now. When these persons enter into a contract, the contract is voidable under 3090 of your civil code. Number 1. Could you look at it for a while? Because you need to know this right now as I am discussing this. Because there are two kinds of voidable contracts mentioned in your 3090, where one party is incapacitated to give consent And these are the persons mentioned in 1327 and 1328. Did you see that? Okay. And the second one, those whose consent is vitiated. Do you see that? And I will give you a mnemonic word for this so that it will be very easy for you to understand and remember. Look, these are the vices of consent. They vitiate consent. Fraud, intimidation, violence, undue influence, and mistake. Okay? Now, what is affected in a contract when the person is incapacitated to give consent to a contract? What is affected? Consent. One of them suffers from that incapacity, or one of them is a victim of FIVUM. The contract is voidable. Okay, here is a minor in that famous Mercado versus Espiritu case in 37 Philippines. And in selling the land, he misrepresented himself as one of majority age. When he attained the age of majority, he filed an action to annul the contract of sale. Let's cut the long story short. The Supreme Court said, while in truth and in fact, you were a minor when you sold it. And when you misrepresented yourself as a person of majority age, you are stopped from claiming to be a minor. It was not annulled. It was not annulled. Here, according to the Supreme Court, there was an active misrepresentation by the minor. He cannot be made to benefit from his misrepresentation. But you know, a subsequent decision of the Supreme Court, which was not even found in the Philippine reports or recorded, Young versus Texon, in volume 39 of the Official Gazette, I think was more reasonable. You know, in that case, the Supreme Court, the same Supreme Court said, a person who misrepresents his age should not be bound by his misrepresentation because he has no capacity to enter into a contract. He has also no capacity to misrepresent himself. Did you understand that reasoning? I have no capacity to enter into a contract. Why make me a capacitated person to make a misrepresentation? But that was forgotten. And in subsequent cases, they went back to the more famous Mercado versus Espiritu in order to discourage misrepresentations. But a subsequent case, Braganza versus De Villa Abril. Yeah, De Villa Abril. But this was a subsequent case, 105 Philippines this time. So many years after. Minors signed a promissory note and a contract of loan. But they did not misrepresent themselves to be of majority age. They simply signed it. They did not disclose that they were minors. They did not also say they were of majority age. Now, when the debtor now wanted to collect from them, they invoked their minority. The Supreme Court said they could invoke their minority. There was no active misrepresentation. They did not misrepresent themselves. They simply failed to disclose it. They were not even asked about their age, according to the Supreme Court. Therefore, the contract as to them is voidable. You get what I mean? Now, could you check 1489 number 2? I was mentioning necessaries in life and a few minutes ago, and you see 1489 number 2. Does it mention necessities in life, necessaries in life? Does it? Okay, and it makes reference to Article 290, is it not? But do you find Article 290 in your present copies of your civil code? Rex Bookstore took them away, okay? Because they were changed by the family code. And those necessaries in life are actually the items of support. So maybe you could go to Article 194 of your family code to see those necessaries in life, because if they are items for support, they are necessaries in life. Oh, did you see them? Okay, now, insanity is, are we presumed to be insane? Or are we presumed to be sane? Now, maybe you look at 800. I have a copy of the Civil Code here. Someone brought it to me or gave it to me. So let's try to look at Article 1800. There could be something here which could help us. Article 800. The law presumes that every person is of sound mind in the absence of proof to the contrary. I am saying because you cannot prove the contrary. Okay, now look. For a person to enter into a voidable contract because of insanity, do you have to obtain a judicial declaration of insanity in order to show the voidability of the contract? The answer is no. Manresa, one of our leading commentators in the Civil Code, says there is no need for a judicial declaration because people by common observation could know why a person or that the person is insane. You will know that your seatmate is sane or insane. Look at each other. But look at this, okay? Let's have a game for this. He is sane, I am insane. The contract is voidable. Follow me? I am insane, he is more insane. And a problem in a bar, you don't talk about who is more insane or is less insane. You will notice, if both are insane, what will be governing this situation is no longer the rule on voidable contracts. You're going to look at unenforceable contracts this time. You look at 1403 number 3. When both parties are incapacitated to give consent to a contract. You know, this law should be amended. Unenforceable ang contract, isn't it? When both are incapacitated. Like pareho kaming minor, unenforceable. Isang minor, isang majority age, para maiksi, isang minor, isang major. Voidable. Pero ang voidable, pwedeng maanal. Ang unenforceable, hindi pwedeng maanal. Kasi valid ang unenforceable contract. Ibig sabihin, pag dalawa ang sira, ay mas effective ang contract kesa kung isa lang ang may sira ang tuktok. Kung isa lang ang may diferensya sa tuktok, voidable, pwedeng maanal. Samantalang pag dalawa ang may sira, hindi pwedeng maanal. You get my point? Espanyol kasi ang nito, Spanish Civil Code. Sa ibang state sa Amerika, pag dalawang insane, void. O mas reasonable yun. Pag isa lang insane, voidable. Sa atin, mas mabisa pa ang dalawang sira kesa sa isa lang. Okay. Have you observed your seatmates now? Okay, let's go to the factors that vitiate consent. Do you see 1330? Do you notice that the last word in 1330 is voidable? And let's rearrange those matters which vitiate consent: fraud, intimidation, violence, undue influence, and mistake. Okay, fraud. Fraud. The other name for fraud is dolo in civil law. Dolo in criminal law in the revised penal code is a felony committed by malice or deliberate intent. In civil law, it's fraud. Now look at Article 1170, the basic provisions on fraud. Those who in any manner contravene the tenor thereof, liable for damages. Those guilty of delay, liable for damages. Those guilty of negligence, liable for damages. Those guilty of fraud, liable for damages. That's the basic provision on fraud and other sources of damages. Now, under our Philippine laws, with respect to contracts, there are two basic types of frauds. One fraud is a causal fraud, and the other fraud is an incidental fraud. There is no definition of incidental fraud in our laws. The definition of incidental fraud is supplied by our Spanish commentators. Incidental fraud has been defined as the intentional proposition. Let me say that again. The intentional proposition to evade the normal fulfillment of an obligation. That is a definition of Manresa, also adopted by Castan. Have you heard those names? Yes, they're ancient names. The intentional proposition to evade the normal fulfillment of an obligation. But there is a definition of causal fraud in our law. Although the word causal is not found, we only can deduce that it is causal. You look at 1338. That is the definition of causal fraud. What do you use? You use insidious words or machinations. Why do you use insidious words or machinations? In order to induce another to give his consent to a contract. It is dolo causante which affects, it is causal fraud which affects consent. Dolo that is incidental or incidental fraud does not affect consent. Well, I'm using these words interchangeably. Causal fraud is dolo causante. Incidental fraud is dolo incidente. This affects consent. This one does not affect consent. Dolo incidente presupposes that there is already a valid contract. And the fraud occurs only in the performance of the obligation. That's why Manresa said it is the intentional proposition to evade the normal fulfillment of the obligation. Let me illustrate. I offered to sell to you 10 sacks of genuine Japanese rice. at 5,000 pesos per sack of 50 kilos. You inspected the sacks. You inspected the contents. Genuine, sticky Japanese rice. 5,000 per bag. 50,000 pesos. You paid me. Then you told me, please deliver it to my house 3 days after. I said, yes. Now let me ask you one question. Is there a perfected contract of sale between me and the seller? The answer is yes. Is there fraud? None. But before I delivered it, I changed the contents to Burmese rice instead of Japanese rice. Burmese rice is not as expensive as genuine Japanese rice. Then I delivered it to you. Is there fraud? Yes. Did you evade the normal fulfillment of the obligation? Yes. The normal fulfillment is to deliver Japanese rice. I delivered Burmese rice. Can you file an action to annul the contract? The answer is no. Because dolo incidente does not affect consent. You can only ask for damages. You look at 1344, number 2. I hope I am right when I mention 1344, number 2. Incidental fraud only gives rise to damages. Yes. It does not give rise to avoidable contract. The fraud mentioned in 1330 is dolo causante, by the way, because the last word in 1330 is voidable. Now, dolo causante is actually a perversion of the truth. There is a false misrepresentation. There is bad faith. It is used to deceive. It is used to induce you to enter into a contract. Dolo causante is serious. But to be voidable, it must be employed only by one of the parties. Look at 1344. If it is 1344, because 1338 must go side by side with 1344. It should be, you will find the word serious there. And dolo causante must be employed only by one of the parties. Oh, I remember my Professor Horado again questioning me on one of these aspects. Whenever he wants to joke me, he would ask me the question. He wants to joke, I would be the butt of his joke by asking me questions. Remember that insane, etc.? His question was like this. I wanted to buy the land. He wanted also to buy the land. So what I did was, I pointed a 45 caliber pistol at him or at her so that she would sign the deed of sale. She also pointed a 38 caliber pistol at me, so I would also sign the deed of sale. And the question to me was, what is the nature of the contract? Void, valid, void, voidable, unenforceable. Before I could answer, he answered, that's valid because the intimidation was used by both. To be voidable, the intimidation must only be used by one. What do you say? I said, sir, I object. It is unenforceable. Why? If both wanted to buy and sell the land mutually, they should not have pointed a gun at each other. Both are insane. And since both are insane, it is unenforceable. You know what he did? He told me to sit down. And I know he was joking, so I also gave him a joke. I miss that old man again. Okay. Did you see fraud? Okay. Dolo causante makes a contract voidable. But dolo incidente does not make a contract voidable. What is the remedy again in dolo incidente? Come on. Damages. What's the remedy when there is dolo causante? Annulment of the contract because it affects consent. Okay. Now here is another matter which may probably we have to consider before we go on a break at 12 o'clock. Oh, I will have your break at 10:30. Now, about failure to disclose facts, would that be fraud? You look at 1339. Could you check if it is 1339? I think it is. Failure to disclose facts. If we are going to interpret that provision, failure to disclose facts is not fraud. Except when there is a duty to disclose and to reveal the facts. Oh, it's very easy to remember. When there is a duty to reveal the facts. And incidentally, your civil code gives you an example only. When the parties are bound by confidential relations, is it not? Confidential relations. Like relationship between an agent and a principal. Those are confidential relations. But maybe I could bring your attention to your former lesson or past lesson in the law on insurance. On concealment. There is a duty to disclose material facts in the contract. When you apply for an insurance policy, contract, there is a duty to reveal the material facts. Those facts which are what? Within your knowledge, isn't it? Do you remember that? And those which you make no warranty about or of. And those which the insurer has no means of ascertaining. Do you remember that? Otherwise, there would be concealment. You disclose material facts within your knowledge. Facts of which you make no warranty of, and which the other party, the insurer, has no means of ascertaining. Because your sections 27 and 28 of your insurance code, there is one principle there. Concealment, whether intentional or unintentional, entitles the insurer to rescind. There is no such thing as concealment in good faith in insurance. There you have the duty to disclose facts. If you don't disclose facts, that will be considered as fraud. Have you come across 1340 on the usual exaggeration in trade? The so-called puffer stock, trader stock, dealer stock. In fact, American jurisprudence calls this provision tolerated fraud. Number one in quality. The soap that will make you immaculately white. After using it, you had bulutong. The best in its class. Have you read things like those? The best in its class. Noong kami mga bata pa, meron ganito, exaggeration. Meron talaga rin yung tide. Hindi mo ba alam na nabihag na ng tide ang bisa ng araw? Gumamit ng tide. Tide. Biro mo yan. Nabihag na raw ng tide ang bisa ng araw. Sabi ng nanay ko, bili ka ng tide. Ayoko na masunog pa ako. Now, are those fraud? The rule is, they are not fraudulent in themselves. As long as the other party has the opportunity to know the facts. Pero kung obviously fraudulent, obviously naman fraudulent. Bumili ng ganitong cooking oil. Paglagay mo sa kawali, tutubo ang itlog. Ay, yun talaga. Yun talaga ang fraud. Because that's too much. Okay. How about a mere expression of an opinion? Would that be fraud? Look at 1341. It's not fraud. Mere expression of an opinion. We're just passing through this. I don't think this will be in the bar, but it could be in the MCQ, not essay. It is not fraud unless it is made by an expert and the other party has relied on that expert's special knowledge. Oh, that's very simple. Now, here is one that is more important. Misrepresentation by a third person. By the way, to be fraud, dolo causante, there is misrepresentation. But the misrepresentation is supposed to be done by a contracting party. Then suppose I talk to you and say, hey guy, you want my land? It's 5 hectares. And I told him that beneath that land are huge ore deposits, mineral deposits. And I am holding with me right now a certificate from the Bureau of Mines about the existence of almost inexhaustible ore deposits there. The truth is, there is none. Believing me, he bought it because he believed in the authenticity of the certification of the Bureau of Mines. After 3 months, he discovered something beneath was not ore, but fossilized manure. Inexhaustible. Is that dolo causante or is it dolo incidente? It's dolo causante. Misrepresentation by a contracting party. It is serious. It is deceitful. It is made by a contracting party. But here in 1342, the question is, it's a misrepresentation by a third person. Is it fraud? Does it vitiate consent? The word fraud is not even mentioned, but you are asked whether it vitiates consent. Yes, possibly, if there was a substantial mistake and that it was mutual. But you will notice if those requisites concur, the voidability is not based on fraud, but on mistake. Because of the word substantial mistake. Those are little things that we have to pass by. But look at 1335 on intimidation, because I'm rearranging this in accordance with our mnemonic word named fivum. Again, what is fivum? What is F? Fraud. What is I? Intimidation. What's V? Violence. What's U? Undue influence. And what is M? Mistake. Yes. So you talk about intimidation, you talk about fear. Fear. Fear of what? How do you describe that fear that would vitiate consent? It must be a reasonable fear. It must be a well-grounded fear. Is that how you study? Fear. What kind of fear? Reasonable fear. What kind of fear aside from reasonable? Well-grounded fear. Fear of what? Of an evil. How do you describe the evil? One that is imminent and one that is grave. Evil that would befall on what? On my person? Yes. On my property? Yes. On the property of my spouse? Yes. On the property of my direct descendant? Yes. And the property and person of my ascendants? Yes. The person and property not only of the party but also of his spouse, of his descendants, and of his ascendants. But sometimes you have to think about fear in relation to the age of the person, in relation to the sex of the person, in relation to the condition of the person. Those are mentioned there. Is it not? In 1335. So, here is a guy who says, if you do not sign this deed of sale of your land, I am going to shoot you. And then he cocks the gun back. And you see fire in his eyes. You signed it. Voidable because of intimidation. I am going to shoot your brother. And you know he was intending to shoot your brother. You signed it. Does it belong to 1335? A brother is not a descendant. A brother is not an ascendant. But a brother should have been included here because you do not want your brother to die. You follow me? This is so restrictive na wala ka ng pakialam sa iba. Ang pakialam mo lang sa intimidation ay asawa mo, ascendants, descendants. Then a gun was pointed at your husband and said, pag hindi mo pinirmahan yan, babarilin kong asawa mo. Sabi ng babae, ituloy mo na. Okay. Now, here is Mr. X, a debtor who never pays me. And I told him once when I met him in the street, if you do not pay me, I will sue you in all the courts of the land. Forum shopping, huh? Okay. Now, he was so afraid. And he said he paid because he was intimidated. Is he right? No, look at 1335. A threat to enforce one's claim does not vitiate consent if it is through competent authority and it is just and legal. I know you are praying for something that I will give you a break now. Give me 5 minutes. Okay. Now look at violence. Violence involves not fear. It involves violence does not involve fear. It involves force. What kind? How do you describe force? Must be serious and irresistible. It is not only force which is irresistible. A person's appeal could also be irresistible. Now, look at undue influence in 1337 before we have a break. When you talk about undue influence, you take advantage of a person. But that advantage is described by law as an improper advantage. You take advantage, improper advantage of what? Of your power over the will of another. What is the effect of that taking improper advantage over your power, over the will of another? It deprives him of a reasonable freedom of choice. So it deprives him of a reasonable freedom of choice. That is the essence of undue influence. But look at certain factors that will affect undue influence. Confidential relations, family, spiritual, mental weakness, ignorance, or financial conditions. So, many of those. The bottom line is, fivum affects consent. It renders a contract voidable. Okay, let's go to mistake before I send you on a break. The mistake that invalidates consent is one that refers to the substance of the thing, or the principal conditions which is the object of the contract under 1331. You bought a horse from Mr. X thinking that that horse is a racehorse, but when you bought it, it was not even want to run, it only wants to sit down. Substantial mistake as to the object of the thing. In fact, you bought it because you wanted a racehorse. You did not want a sitting horse. But there is no mistake if at the first outset you already had a doubt as to the object. Like in 1333. Kung duda ka na, walang mistake. So the mistake that invalidates consent is a mistake referring to the substance of the thing and to the principal conditions, which actually was the cause for the contract. But there is one important aspect of mistake. Would mistake as to the identity or qualifications of one of the parties vitiate consent and result to mistake? Yes. If actually that identity or qualification is the principal cause of the contract. The rule is no. But there is a very important exception here. When the identity or qualification is the principal cause for the contract. Look, I donated a parcel of land to this young man because I thought he was my long lost son. After the donation, I discovered he was not my son. He was the son of my enemy, not my son. There was mistake. His identity and qualification was so important to the contract. It will vitiate my consent. Okay. Does being a minor vitiate consent? No, he is incapacitated. Okay? Remember, there are two factors that make a contract voidable. One party is incapacitated. The other is consent was vitiated. What do you call the general terminology for fraud, intimidation, violence, undue influence, and mistake? Answer, they are the vices of consent, and they render the contract voidable. Before you go on a break, the way I do, what kind of fraud makes a contract voidable? Does every kind of fraud make a contract voidable? No. What kind of fraud? Causal fraud. And what is the other name for causal fraud? Dolo causante. Let us break ourselves.